Good evening, all of you lovely people, and welcome to this evening's Think Legal webinar, Understanding ANCs, and specifically understanding anti-nuptial contracts and matrimonial property regimes. It's great to see all of you this evening following along on StreamYard as well as on LinkedIn, YouTube, and Facebook. The link has been shared on the WhatsApp link, so you should be able to follow along from the link which I shared on WhatsApp. So, folks, let's get into it. Joining me this evening is Notary Public Johan Muller, who's a colleague and a good friend of mine. He assisted me to put this evening's presentation together, and he has also taken responsibility for preparing our slides. So thank you so much, Johan, for joining me this evening, and I look forward to going through the slide deck which you have prepared for us. Folks, tonight's session is very much a 101 session insofar as anti-nuptial contracts are concerned. When we look at anti-nuptial contracts, the interpretation of anti-nuptial contracts and the implications thereof, specifically where we are seeing daily advancements and changes to the law regarding customary marriages as well as religious marriages, we do foresee a lot of changes coming in. So just please take note that it is going to be a fairly 101 level webinar. We are planning on doing a more in-depth 102 or 201, as the case may be, webinar on the topic. And please keep your eyes peeled for that. Presentation length this evening should be approximately an hour and 20 to 30 minutes, depending on the interaction that we get from all of you this evening. Since we are on StreamYard, unfortunately, we can't ask you to unmute and ask your questions, but I am watching our chat bar like an absolute hawk, and I am more than happy to answer some of the questions you might have while reserving the particularly tough ones for Johan, who is not at all nervous about tonight's presentation. So, folks, let's get into it. I'm doing my slide share a little bit differently this evening. So I've got our slides open as well as the Matrimonial Property Act as well as the Deeds Registries Act, because we are going to be looking at these a little bit later on. So please do be patient with me if there are technical hiccups. I will try my utmost to ensure that there are no technical hiccups. If my mouse cursor starts making you seasick, because I do have the tendency to play with the mouse cursor as I'm doing now on your screen, please can I just ask someone to alert me in the chat and say, listen, sit still, you fidgety person, you. Right. So, as we know, folks, all marriages end either by death or by divorce. And essentially, in South Africa, we are quite fortunately in a position that the ease, simplicity, and fairness of that ending is often determined by the marital property regime, which the parties choose before getting married. And then obviously the decision to marry in community of property or with an anti-nuptial contract determines who gets what in the case of death or divorce, subject obviously to legislative exceptions to the rules, such as our forfeiture provisions in the Divorce Act, adjustment provisions in the Divorce Act, and the redistribution provisions in the Divorce Act, which we will look at a little bit later. Obviously, we know that entering an anti-nuptial contract or not entering into an anti-nuptial contract is an important decision to be taken by parties. Now, what is important, and I appreciate that Johan put this in right at the front for us, is that it is often problematic for parties to discuss antenuptial contracts as part of their wedding plans. It's a fairly unromantic, unexotic document to have to discuss, and we often get quite a few objections from parties saying, but we love each other and we are fond of each other and it is forever, so why marry out of community of property? Obviously, all marriages end one way or another, even though it's not nice to think of. So one needs to take into account these things. Furthermore, as we'll see a little bit later on, a good and well-planned matrimonial property regime can actually contribute to a more harmonious marriage, and it can also enhance the parties' abilities to transact on their own behalf and to mitigate the risks of being married in community of property. Oh, I'm seeing so many lovely familiar names in the chat bar, and I'm so thankful that all of you have taken the time out to join us this evening on the 11th of March, Tuesday, in a rainy Johannesburg. So what I'd like to first go through, folks, is the marital property regimes in South Africa. As we go into this, please do bear in mind that this is a topic which is under quite serious scrutiny, both inside and outside of the courts. We have had some very, very interesting developments in the last year or two with our constitutional invalidity of Section 7.3 being limited to marriages before 1 November 1984. We have now seen that extended last month with a further judgment dealing with pension interests under a Section 7.3 adjustment, which we'll deal with a little bit in the Family Law Roundup this Friday. For those of you who haven't registered yet, please do jump in. So these matrimonial property regimes are not necessarily the final word, but they do set in place a default position in the case of divorce. There are exceptions to the rule. However, those exceptions to the rule need to be properly pleaded, properly ventilated in the divorce trial, and can only serve to disrupt the default position under certain circumstances. Now, as we know, the three matrimonial property regimes in South Africa, for now at least, are marriages in community of property, marriages out of community of property without the accrual system, and then marriages out of community of property with the application of the accrual system. And I will briefly go through these matrimonial property regimes, bearing in mind that it is evening and we all do want to not sit here until midnight. So for those of you who have attended any of our trainings on matrimonial property regimes, you'll recognize the two faces over there and the little pot with assets and liabilities in between them. And this is representative of a marriage and community of property. And essentially what the circle delineates or represents is the joint estate which comes into being between our two parties the moment they say I do and they comply with all the formalities of the Marriage Act. The minute that happens, a joint estate comes into being and all of their erstwhile separate assets and liabilities become part of the joint estate, and they are co-administrators of this creature known as the joint estate. Now, our standard characteristics of a marriage in community of property are as follows: that all assets and liabilities form part of one communal estate. Both parties are co-owners in undivided and equal half shares of all assets in the joint estate, and both parties are jointly responsible for the liabilities of the joint estate. In terms of administration of the joint estate, the parties are co-administrators of the joint estate, which means that both parties have equal responsibilities for transacting on behalf of the joint estate. The one benefit, and I would go so far as to very cynically, but I think very realistically say, the only benefit of being married in community of property in this day and age is that no antenuptial contract is required to get married in community of property. So the parties will save a little bit of money getting married without an antenuptial contract, but penny wise, pound foolish, as they say. And one of the main reasons for this penny wise and pound foolish effect, folks, can be found in Act 88 of 1984, which is our Matrimonial Property Act, and specifically Chapter 3, which deals with marriages in community of property. I'm going to zoom in as far as I can on our Section 15 of the Act, and I hope that everyone can see it. The main drawback, folks, is that for a marriage in community of property, apart from the fact that spouse one is held responsible for the sins of spouse two when they incur liabilities, etc., is that the parties have limited transacting capacity when it comes to transactions in terms of Section 15.2 and Section 15.3 of the Matrimonial Property Act. In terms of Section 15.2, one needs written consent from a spouse to conduct certain transactions. And in terms of Section 15.3, it simply states consent. So it can be inferred that verbal consent would be sufficient, not sufficient. That's not a word in this instance. So what are these transactions which you are not permitted to enter into in terms of Section 15.2 without written consent? And that is the alienation, mortgage, burden with a servitude, etc., over immovable property. And then B goes together with A, enter into a contract for alienation, mortgage, etc. So you cannot deal with immovable property in the joint estate, even if that immovable property was owned by the party wishing to transact with it prior to the marriage in community of property. You cannot alienate seed or pledge any shares, stock, debenture bonds, etc. You cannot sell shares, essentially. What I found very interesting is you cannot alienate or pledge jewelry, coins, stamps, paintings, etc., which are held mainly as investments. You cannot withdraw money held in the name of your spouse without their written consent. You cannot enter into a credit agreement as a consumer. And this one is particularly interesting and obviously came into effect with our National Credit Act in 2005. You cannot incur debt in your own name without the written consent of your spouse if you are married in community of property. Cannot enter into an alienation of land act contract, and you cannot bind yourself as surety. I'll quickly run through the Section 15.3 things. You cannot get rid of any furniture or other effects of the common household without consent. You cannot receive any money due or accruing to your spouse by way of various things under subsection B without their consent, and you cannot donate to any other person any asset of the joint estate without value. Now, what is important to know in terms of Section 15 of the Matrimonial Property Act, and for those who just joined us, we are talking about the drawbacks of marriages in community of property, is that Section 15, 9, A and B exists, and Section 16.2 exists. In terms of Section 15.9 of the Act, if you were naughty, if you entered into a Section 15.2 or 3 transaction during the marriage without consent, you knew or reasonably knew that you would probably not obtain consent, and the joint estate suffers a loss. At the time of divorce, an adjustment can be effected against you if you are naughty in that instance. Section 16.2 is our preemptive relief, whereas our Section 15.9 is back-looking or rear-looking relief, i.e. at the end of the marriage, the naughty acts have already taken place. Retrospective relief, if we can call it that, or retroactive relief, whereas Section 16.2 is proactive or forward-looking relief, in that the court can, on application, suspend for a definite or indefinite period any power which a spouse has to exercise certain powers in terms of the joint estate. Now, you will note in terms of Section 17, there are significant limitations on litigation by or against spouses, which does warrant a mention, but you are welcome to go and have a look at Section 17. So, as I mentioned to you folks, the benefit, and in my view, respectfully, the only benefit to being married in community of property is that no antenuptial contract is required. The second situation that we want to look at is marriages out of community of property, no accrual. And these are our oldest form of marriage out of community of property in South Africa. And these are the ones that really caused quite a lot of controversy in our KG versus Minister judgment, which went all the way to the Constitutional Court, which we'll have a look at a little bit later. What a marriage out of community of property entails, folks, is that each party has their own separate estate during the subsistence of the marriage, as well as after the marriage. So where in a marriage and community of property, you have one pot containing all of the assets and liabilities, in a marriage out of community of property without the accrual, there are two very, very distinct and separate pots, one belonging to each party. Now, what is interesting about our marriage out of community of property without accrual is that parties can still allege and prove a universal partnership, or authority suggests that at least, and that's RD versus TD 2014 for SA 200 GP as our citation reported case in that instance. However, in general, most marriages out of community of property without the accrual are very, very simple in nature, unless there is a Section 7.3 case or a universal partnership scenario, in that each party's assets and liabilities form part of their own separate estate. Neither party has any claim to the assets of the other, nor are the parties liable for the debts incurred by the other. Each party is the sole administrator of their estate, And as I mentioned to you, this is a non-default position, whereas in community of property is a default position. For a marriage out of community of property, you are required to enter into an anti-nuptial contract. Now, very important, folks, anti-nuptial contract, if one just separates the words, it is a contract and it happens anti, i.e., before the nuptial, wedding, marriage, etc. So it is a contract entered into before the marriage. I am quite alarmed at the number of inquiries which we receive from parties who say, we got married 2 weeks ago, we would like to do an anti-nuptial contract, please can you assist us, which is a scary situation. But obviously we know anti-nuptial means before. In popular culture we speak of prenups, as you are most acutely aware. Now, in 1984, in terms of the Matrimonial Property Act 88 of 1984, from the 1st of November 1984, we had this new creature called a marriage out of community of property with the accrual system. Now, if all of these arrows and bubbles and expressions on your screen look complex to you, don't panic. It is just because they are. Now, when it comes to marriages out of community of property with the accrual system, there are various principles that we need to take into account. It is not a simple case of saying everything is shared 50-50. It is also not a case of saying that both parties retain their own assets. It becomes a little bit more complicated, and I'm going to try and very simply take you through the core principles of accrual marriages as we go through the session tonight. I know that my friend Stella is in the session tonight. I saw her saying good evening earlier. I know she does a wonderful CPD training on how to calculate the actual accrual claims. I believe she is going to be presenting it in May of this year again. So Stella, once registrations open, please do let us know. And if you have registration details, please can you pop it in the comments for those who would like to go and see your training in May. I'm, however, not going to go into the numbers. First off, because, well, I'm an attorney and numbers scare me, quite frankly. Secondly, it is late in the evening, so I'm not going to do that to you fine folks who are in this session. And thirdly, it is a 101 level kind of discussion on anti-nuptial contracts in general and the implications and consequences of anti-nuptial contracts. So, what is a marriage out of community of property with the accrual? Now, first off, let me just bust a myth which we see once again scarily often, and that is where people conflate our marriages out with accrual with the position in some continental European countries where it is almost a situation of everything that you have before the marriage is in a separate estate, and everything that you accrue during the marriage or you obtain during the marriage then becomes shared. That is not an accrual, folks. An accrual claim is a cash claim, as I will show you a little bit later. Now, what happens when you get married with the accrual. I'm laughing at Stella. Stella says, thanks, Mervyn. Will do. We'll open registrations next week. Training will be on 24, 25, and 26 May. Folks, I know Stella runs this as an evening course. Poor Stella had no idea I was going to tell you guys about her course. So she very quickly had to type very furiously. But do join Stella for that session. I've sent most of my candidate attorneys and paralegals to attend it, and the feedback that I've received was absolutely amazing. Plus, Stella might buy me a whiskey if I send her enough clients. So, neither party during the marriage has any claim to the assets of the other, nor are the parties liable for debts incurred by the other. So, during the course of the marriage, folks, an accrual marriage is exactly the same as a no accrual marriage, save for the parties' obligation to act in good faith. You cannot simply, in the face of an impending divorce, go and donate all of your assets to charity, or more often to your brother or sister, which is something we see, unfortunately, happening quite a lot. And then secondly, you have the obligation in terms of Section 7 to account to one another in terms of your estate. Apart from that, it is a separate estate. There is no sharing of assets in an accrual marriage, with the notable exception that if the parties buy a property together. For example, parties can be married subject to the accrual, and they can still be co-owners of an immovable property. That happens very, very frequently. The parties still remain the administrators of their own separate estates. There is no co-administration of a joint estate. However, we know from decided cases that parties have the requirement of acting in good faith. As is the case with marriages out and out, an antenuptial contract is required for the parties to get married out with accrual. Now, the Matrimonial Property Act, folks, was drafted all the way back in the early 80s, came into effect in 1984. It is essentially very, very long overdue for a bit of an overhaul or a retirement, if one thinks the difference in South African society between 1984 and 2025. Check my math, Stella, please, but I believe it's 41 years, or just over 40 years if we go into November for the commencement of the MPA. What is relevant about that, and I'm not just waxing lyrical, is that there was a very interesting style of drafting legislation back in the day, and that is that we have these very, very long, convoluted sentences in certain places. And Section 3.1, I think, is one of those quite convoluted sentences, which I'll share with you. And this really sums up the accrual system in a nutshell. And it is that at the dissolution of a marriage subject to the accrual system by divorce or death of one or both of the spouses, the spouse whose estate shows no accrual or a smaller accrual than the estate of the other spouse, or his estate if he is deceased, acquires a claim against the other spouse or his estate for an amount equal to half of the difference between the accrual of the respective estates of the spouses. One thing they also did not know how to do in the 80s was to use gender neutral terms when it comes to drafting legislation. But be that as it may, this is our accrual system in a nutshell. Section 3.1 stipulates that at the dissolution of the marriage in one of two ways, death or divorce, this accrual claim is calculated and comes into being. The claim only arises at divorce. There is no claim before date of divorce when it comes to an accrual claim. Now, let's have a look at how this functions in practice, folks. Let's look at a very basic conceptual accrual calculation. Now, if we look at Section 4 of the Matrimonial Property Act, it sets out what the accrual is, folks. And the accrual is the amount by which the net value of the estate of the spouse at dissolution of the marriage exceeds the net value of their estate at the commencement of the marriage. And what is important about that is that we have two very pertinent dates where we need to do a calculation, or one date on which we do a calculation and another date where it is either deemed to be zero or the parties would have stipulated in the antenuptial contract what their accrual or their commencement value is very, very clearly. So you have a starting point, you have a finish line, and you have to calculate the difference between the two. So if I start with 10 Rand, I finish with 100 Rand, my accrual is 90 Rand. However, there are certain rules that come into operation by virtue of law that we need to take into account, which makes this not as simple as it seems. So let's say my estate grew by 90 Rand over a period of 20 years. Right. 90 Rand today ain't 90 Rand 20 years ago. This is where our first kind of kink in the cable comes in, and that is that the net value of the estate is calculated with due allowance for the difference which may exist in the value of money. So you have to adjust your commencement value in terms of the weighted average of the consumer price index. And I know Stella's got a lovely table that she does that. I will very respectfully refrain from doing that this evening because I might hurt myself or you fine folks if I do that. The second interesting thing about an accrual is the fact that there are assets which can be excluded from the accrual. Those assets which are excluded are, for example, an asset which you exclude in terms of the antenuptial contract. So the spouses can say, for example, I have an immovable property, it's paid off, I am not sharing this at all. This is ring-fenced, it's out of the way. Further, inheritances, legacies, and donations in terms of Section 5 are excluded from the accrual. And this is a very, very interesting section if one takes the time to analyze it, the situation of inheritances, legacies, and donations from third parties and between spouses. So do take note of these ex lege operation of law type of exceptions to the rule or exclusions specifically. Now, when entering into an antenuptial contract, folks, sorry, wrong screen. There we go. Let's just go back to StreamYard. I'm making you folks see 6. Sorry about that. When entering into the antenuptial contract, very importantly, in terms of Section 6 of the Matrimonial Property Act, the parties can essentially do a declaration of what their commencement value is, or they can at a later stage file a document setting out their commencement value, or they can leave it blank, in which case their commencement value is deemed to be null. Now, when the marriage comes to an end, you have to now start calculating the accrual. And essentially, there are 4 steps that we need to go through in calculating the accrual. You look at the commencement value. It's either contained in the ANC itself or in a statement by the parties, or if there was no commencement value stipulated, it is null. That's Section 6.4b, and then you have to adjust the commencement value by the weighted average of the consumer price index, which is quite a fun exercise to do. Next up, you disregard excluded assets. So assets excluded in the ANC, damages for non-patrimonial loss, inheritances, legacies, and donations between spouses. These are excluded. You calculate the dissolution value or the ending value, and that's always going to be a ballpark unless and until there is a divorce date set in stone, because things change. And then finally, you calculate the difference between commencement and dissolution values. Right, here's a very interesting question. What happens in the case of married out of community of property with application of the accrual, where one party racks up an enormous amount of debt and the other party knows nothing about this? Does this debt still have to be taken into account in calculating the accrual? Yes, absolutely it does. Remember, as I mentioned to you earlier, the parties have the obligation, or they have the right to solely administrate their estate. So, in this instance, in terms of the administration of the estate, they can transact freely. They do not have to seek consent. There is no mechanism for accrual marriages like a Section 15.9 where there is an adjustment. You only work on your net asset value. Right. Now, let's just take that a step further. If party B racks up an enormous amount of debt and they end up being worth minus 10 billion, their accrual will still be 0. There will be no negative accrual. 0 is where it stops. However, the one little provision which we need to take into account with this issue of the debt is still Section 9.1 of the Divorce Act. Let me give you a scenario. Parties are married subject to the accrual. Both parties have a fairly healthy accrual. They were quite prudent in managing their finances. And let's say the husband is the naughty one in this instance. Wife conducts her business very, very prudently. Husband conducts his business prudently, but the minute he gets wind that there's a divorce coming up, he takes out 10 million rands worth of unsecured debt at 23% interest, takes the money, goes and fritters it away at the carousel, and now all of a sudden he has an accrual claim against the wife. Section 9.1 of the Divorce Act says that parties can be ordered to forfeit the patrimonial benefits of the marriage if the court is satisfied that having regard to duration of the marriage, misconduct on the part of either of the parties, or the circumstances which gave rise to the breakdown of the marriage, one party will be unduly benefited in relation to the other if an order for forfeiture is not granted, then it can order forfeiture. So the court can still order a forfeiture of in respect of that. Importantly, if you look at Section 9.1 of the MPA, or 9 of the MPA, ironically, Section 9.1 of the Divorce Act is forfeiture. Section 9 of the MPA is also forfeiture. And essentially that says that the right to share in the accrual of the estate is a patrimonial benefit, which may on divorce be declared forfeit, either wholly or in part. Now, when we get to the calculation of the accrual, I've got my little example here where we've got our commencement values and closing values, and there are all sorts of, sorry, I'm on the wrong screen on your side. There we go. There are a lot of figures here, but let's say the bottom line is that the husband's estate grew by 9.8 million, wife's estate grew by 5.292 million in this example. The difference between it is 4.59 million. In other words, you take 9.8, deduct 5.2, and you are left with 4.59 million, as you can see on our slides. What Section 3.1, you remember that really convoluted section we looked at a little bit earlier, provides is that the husband in our scenario on the screen now would have to pay the wife an amount of 4.59, or there's a difference of 4.59 million, apologies, and what needs to be paid over is then half of that, 2.295 million, which means that both of them walk out with an accrual of 7.587 million rands. It is the great equalizer. Accrual marriages have this great equalizing kind of, shall we say, effect at the ending of the marriage, in that the accrual is then calculated and the claim is then paid. One last thing that I want to mention to you folks about the accrual is that if the husband in our scenario then comes and says, I don't have 2.5 million rand lying around, realistically, it could be tied up in assets. It could be tied up in share options which have not yet vested. And yes, Stella, share options have value for purpose of the accrual. Ask the SCA. We'll argue till the day we die about this, Stella, in any event. But the husband can, in this instance, approach the court on application to defer the satisfaction of the accrual claim in terms of Section 10. Why is that? Well, it's a cash claim, friends and colleagues. It is a claim that needs to be paid over in cash. If you don't have sufficient cash available and you do not have assets capable of being liquidated without substantially prejudicing one or both of the parties, a Section 10 may be brought. And the court can put in quite a lot of conditions, as you can see: furnishing of security, payment of interest, payment of installments, delivery or transfer of specified assets. And the test here is as the court may deem just. Now, that is our accrual essentially in a nutshell. Now, what I would like to go through next is some interesting cases which Johan has put together for us. Thank you, Johan, which I think are quite relevant for our purposes this evening. Now, what you will have noticed, guys, is that I have spent a lot of time speaking about matrimonial property regimes, because the main function of an antenuptial contract is to regulate the parties' matrimonial property regime, as it were. Now, first off, I want to share with you the judgment of KRG versus Minister of Home Affairs and others. Please be aware of this judgment. It is a very, very important judgment, which the Constitutional Court confirmed an order of the North Gauteng High Court at a later stage. I see, Johan, you've got the Safley citation for the North Gauteng High Court in there. We do have the confirmation from the Constitutional Court as well. And I think it is cited as EH versus Minister. And I will share it with you shortly. Johan, if you can perhaps just do me a favor and go on Safley and just find the Constitutional Court judgment of the KRG matter, and then we can just share the citation in the comment box for those who would like to follow along. Now, I'm going to very, very briefly take a crack at explaining to you what happened in the KRG matter. And essentially, before KRG came into existence, there was a distinction between two classes of people married out and out. Those married prior to 1 November 1984 and those married after 1 November 1984. And the operative D-Day being that 1 November 1984 was when the Matrimonial Property Act came into operation. Now, before the Matrimonial Property Act came into being, there was a common law marital power which existed, where the husband had power over the person and property of their wife. Obviously, something which is very foreign to us in 2025. But when the MPA came into effect in 1984, this was quite groundbreaking stuff. And the what was groundbreaking is the fact that the MPA then abolished the marital power. And what happened essentially prior to 1984 was that a wife was put to an election: either get married in community of property and be subject to this marital power, or get married out of community of property, and then you have no claim against the growth in the estate of your husband's estate, as it were. And I'm specifically speaking of husband and wife here, being sensitive to the reality that there was and remains a power imbalance when it comes to marriages where the husband generally has more bargaining power than the wife, even more so back in the mid-80s. Now, what happened was in 1984, 1 November, the Matrimonial Property Act came in, and it made huge waves in terms of abolishing the marital power, but also in terms of the fact that it brought the accrual into our into our law. Thank you so much, Johan. Folks, please have a look on your screen. I'm going to share the citation with you. So for those who would like to go and have a look at the Constitutional Court judgment, it's EB Born S versus ER Born B and others, semicolon KG versus Minister of Home Affairs and others, CCT 364/2021. And our SA Law Reports citation 2024-2 SA1 CC is our Constitutional Court judgment. Really worth a read in terms of the reality of gender bias and unequal bargaining power of genders still in South Africa. Now, when this legislation came in, and sorry, folks, I'm having a heck of a time with my contact lenses, so I'm not too tired to hang out with you folks. My eyes are just a little bit scratchy at the moment, if you do see me rubbing my eyes quite a bit. What happened after 1 November 1984 at that stage is that you were faced with a whole class of people who got married prior to 1 November who did not have the option of getting married with an accrual system. And this obviously would have led to an unfair situation. And what was then brought into consideration there is that there was this adjustment claim which was brought into being by the Matrimonial Property Act, which essentially provided that if you are married out and out, and if you were so married prior to 1 November, you could, in terms of Section 7.3 of the Divorce Act, institute an action for a transfer of certain assets subject to certain conditions. Now, obviously, over time, Section 7.3 of the Divorce Act went fairly dormant. Why? Well, because everyone who was married before 1984 either got to the point where they had either passed away, the generation had kind of moved on, or they had reached the point where they decided to ride it out. I mean, if you were married prior to 1984, just before the KG judgment, which was towards the latter half of 2023, then essentially you would have been married for nearly 40 years at that stage. So these claims really went quite quiet, and then along came this KG judgment, in terms of which what had happened is the North Gauteng High Court had almost, one can almost say, shimmy or jury-rigged the provisions of Section 7.3 to achieve equality and fairness where there was no other mechanism available to the parties. Is it an ideal way to achieve equality and fairness? I'm not so certain, but in the absence of adequate law reform, the courts are doing what they can, and litigants are doing what they can in terms of the mechanisms available to us, though imperfect, to get justice for deserving people. So what happened in KG specifically is there was a declaration of invalidity that this Section 7.3 remedy only exists for spouses married before the Matrimonial Property Act. It is now universally available to parties married out of community of property without the accrual system. Right. Now, that is our KG judgment. Very interesting other judgment, which I would like to share with you, is IR versus HR, which Johan picked up for us. And this is a Johannesburg High Court judgment. We've put your Safley citation on there. And this was 12th of February 2020. Lamont J. presiding over the matter. And essentially, it is a nice exegesis on excluded assets in terms of an antenuptial contract, and the fact that the party alleging the exclusion has the obligation to prove the exclusion. So, for example, in terms of Section 4 of the Matrimonial Property Act, let me just take you there, making everyone quite seasick by scrolling. In terms of Section 4(1)(b)(2), a party can exclude an asset from their accrual. I gave you the example earlier, folks, of a party saying, look, I have this paid off house. This is something completely separate. If they exclude that house and they sell that house, and with the proceeds, they purchase another house, the second house is also excluded. In other words, an asset which has been excluded from the accrual system, I'm reading from Roman numeral 2, and then second line, as well as any other asset which he acquired by virtue of his possession or former possession of the first mentioned asset, is not taken into account. So you have to plot a golden thread to say, I've got the second asset because of the first asset. One is reminded of the nursery rhyme, there was an old lady who swallowed a fly. And now that will probably be stuck in most of our heads for the remainder of the evening and the next time you have to deal with exclusions in an accrual situation. So you are welcome, friends and colleagues. The reality is, if you don't swallow the fly, you don't swallow the frog, you don't swallow the cat, you don't swallow the snake, you don't swallow all of these different things. The seed asset must give rise directly to the replacement assets for the exclusion to be applicable. Now, I also want to talk to you as we close off and before we go into the question and answer section, our legislation essentially dealing with antenuptial contracts in South Africa. We've looked quite extensively at the Matrimonial Property Act, folks, and in terms of looking at the Matrimonial Property Act, we've gone through quite a lot of sections. Now, you might be wondering why I focused so much on the Matrimonial Property Act, and that is simply because the Deeds Registries Act, being our other relevant legislation when it comes to antenuptial contracts, only has a very disappointing 4 sections which I can look at. So if I was just doing these, it would be a disappointingly short webinar this evening. Now, folks, let's talk about how an antenuptial contract comes into being. Now, when you essentially decide to enter into an antenuptial contract, it is not as simple as just signing the agreement. The antenuptial contract must be notarized and it must be registered at the deeds office to be enforceable against third parties. Now, case law provides that if an antenuptial contract is not registered with the registrar of deeds, but it is duly entered into between the parties, the contract is still enforceable inter partes, i.e., between the two parties. But as far as third parties are concerned, the parties are married in community of property. And yeah, if I may ask, Johan, if you want to quickly go and have a bit of a speed research and find our citation for the case law on the proposition that if an antenuptial contract is not registered, it is still in force inter partes. Right, so what are our requirements? Number one, the antenuptial contract must be notarized, i.e., it must be signed before a notary public. Now, when we sign a document in front of a notary public, it can be done either by the parties acting personally or by virtue of a power of attorney, which they generally give their attorney who consulted with them to sign it on their behalf in front of the notary public. So it is not uncommon to see antenuptial contracts with the same signature appearing for both intended partners or spouses when you get the deeds office copy. In those instances, all you need to do is contact the notary and you will find the power of attorney in the notary's protocol where the parties would have given a power of attorney to a person who signed. Now, as we know, folks, you have to sign your antenuptial contract, ante the nuptials, and ante with an E, not anti, A-N-T-I. Heavens forbid hearing the terms anti-nuptials from a family lawyer. We are anything but anti-nuptials. This is A-N-T-E nuptials, which is prior to the marriage, not opposed to the marriage. Once the agreement has been signed, it is notarized, and it must then be registered with the registrar of deeds within 3 months. And that is in terms of section 87(1) of the Deeds Registries Act. Now, there is a backstop for parties who did not enter into an antenuptial contract or who, for whatsoever reason, failed to register their antenuptial contract timeously. And that comes in terms of section 89 of the Deeds Registries Act. And then also, if we go all the way back to the MPA and I scroll, you'll see down to section 21, the parties can approach the court to change their matrimonial property system at a later stage. Now, there are two distinct situations which arise. The one is a situation where the antenuptial contract was signed, but the formalities were not complied with. And the second instance is where the parties got married subject to no antenuptial contract, for example, in community of property, and then they want to change to out of community of property, or they got married with accrual and they want to change it to no accrual, or no accrual and change it to accrual, or whatever the case may be. Now, for those of you who are in the game of doing antenuptial contracts within your practice, obviously we do have the lovely saying, be afraid, be very, very afraid. And that really comes down to several judgments which are quite important. The first one I want to share with you folks is the 2014 Supreme Court of Appeal judgment of B versus B. Now, this is just a quick crash course in why it's so important to get it right. And I'm going to share this on your screens for those of you who would like to go and look for this judgment. The head note of this judgment, friends and colleagues, once again, Supreme Court of Appeal judgment. So it is binding on our superior courts, including the high courts. The terms of an antenuptial contract inconsistent and incoherent. The context did not clarify precisely what the parties intended to achieve. The contract void for vagueness, and the marriage thus in community of property. Now, very, very important when you draft antenuptial contracts, make sure that what the parties intend to achieve is very clearly set out. Because if it is not, and if there is any form of vagueness or contradiction, then you will be faced with a B versus B scenario, and the parties will then be married in community of property. If there is vagueness, the whole ANC gets kicked out and you are married in community of property. And that, quite frankly, is a scary proposition. The second caveat is obviously the registration of the document at the deeds office, and that is something that must take place within 3 months. And if it does not, attorneys and or notaries or lodging agents, or all of them combined, can be in very, very hot water. Now, as we draw this 101 level introduction or understanding ANCs to a close, I want to circle back to what Johan said right in our beginning slides. And it is that while it can be problematic to discuss an ANC at the commencement of the marriage, it is very important for potential spouses to fully consider their position before getting married, and to act accordingly in terms of entering into an antenuptial contract as and where appropriate. And if they do decide for whatsoever reason to get married in community of property, at least they will do so with open eyes and understanding what the risks might be. Now, as we close off this evening's session, I am going to invite you to raise any questions that you would like to raise for myself and Johan. I'm more than happy to tackle the substantive law questions in terms of the matrimonial property regimes, and Johan is on standby to tackle any questions regarding the notarization and registration elements of the antenuptial contract process. Obviously, being on StreamYard, folks, we are working on chat boxes, and we are working on obviously no on camera and all the rest. Let me get this out of the way while we do that. I see that I've got one or two coming through on WhatsApp for some reason. And let me quickly just get my WhatsApp open and see what the parties have to say there. The question that I just got, folks, let me just get it open, is if you sign an antenuptial contract, is it necessary for both parties to seek independent legal advice? Now, this is an incredibly interesting question because, in terms of South African law, not necessarily. Internationally, more so than in South Africa, but we are moving there. One of the guiding principles in South African law is a caveat called caveat subscriptor, where there is an assumption that if you sign a document, you do so freely, voluntarily, with an understanding of what you signed. There is also the further provision of pacta sunt servanda. People must be kept to the agreements that they make. Nevertheless, we still see a plethora of cases when it comes to divorce where parties say, I didn't know what I was signing. Someone just came in with this contract. I was excited for the wedding, and they said, sign this or I'm not marrying you. It is something that happens. In jurisdictions outside of South Africa, there are notably Australia, and some of you who are in international practice will know that Australia essentially views an antenuptial contract as worth a little bit less than the paper it is written on. But they are allowed to take it into consideration in exercising their discretion on divorce for proprietary settlement. One of the things they do look at is whether the parties were independently advised, and some other major jurisdictions across the globe do have that requirement. Right, now we've got some very interesting questions coming in. We've got a question: can any attorney draft the antenuptial contract but hand over to the notary? And the answer on that is a resounding yes. All the notary has to do is to notarize the document. In other words, they act much like a commissioner of oaths, but a commissioner of oaths with a bit more sting behind them, because they have to do an extra kind of exam, at least in South Africa. A funny story that I can share with you folks is I recently qualified as a solicitor in Scotland. So I'm a notary in Scotland, but not in South Africa. And I practice as a notary in neither. But in South Africa, there is this further requirement of an exam, where in a jurisdiction like Scotland, there is not. So Johan, for example, is a notary public. He had a separate exam to write, separate admission, and that allows him to notarize. The drafting, however, can be done by an attorney. Vim asks, is inheritance part of the joint estate in an in-community of property estate? Now, this is very interesting because there is a distinction in the Matrimonial Property Act. As you saw earlier, an inheritance is excluded from the accrual by virtue of the Matrimonial Property Act. No such provision in terms of in-community of property. So the inheritance in an in-community of property estate, resounding yes, it is a part of the joint estate. However, if the testator or the testatrix in the will specified that the inheritance shall not form part of a joint estate or an accrual, as the case may be, then it will be excluded. The will of the testator or testatrix will then essentially trump the in-community of property experience. Pratima says, thought-provoking and complicated material, Mervyn and Johan, especially for a flu-ridden head. And Pratima, I wish you a very, very quick recovery. And thank you for joining us, even though you are not feeling well. Right, so Hlengiwe says, thank you for an insightful session. You discussed the solution for ANC and accrual as it relates to divorce. Does it mean the same considerations are not true in the case of dissolution as a result of divorce? I'm assuming one of these two refers to death. Secondly, could you touch on whether the same ANC requirements apply for a customary marriage? Now, this is very, very interesting subject matter, and we have got, I think we a plethora of judgments coming out in this instance. The requirement for an antenuptial contract to be signed is the same for a customary marriage in terms of the Recognition of Customary Marriages Act. For further reading, go look at Section 3.1 of the Customary Marriages Act, and some very interesting new case law in the last year that's come out. In the Family Law Roundup, we've got at least 4 or 5 customary marriages cases every month coming out from the various divisions. One of the more interesting ones was, I believe it was from the Limpopo High Court quite recently, where the judge said, we must understand, and the judge quite clued up on customary marriages, and he said, one must understand that a lot of customary marriages are entered into by parties with the understanding that they would be doing a civil marriage, and they do the customary rites to basically appease the customs of their culture and ancestors, etc. But they don't intend to get married there. Their intention is that the civil marriage is the marriage. And in that instance, in that judgment, the court said, well, there was no intent in terms of Section 3.1 for the parties to marry, even though they went through all of the customary rites of lobola, of the handover, etc., all of those rites which really can become very complex and very varied across South Africa. And the antenuptial contract that they signed after the customary marriage, before the civil marriage, was in that instance seen to be valid. There is, however, case law as well where the customary marriage was entered into, then the antenuptial contract signed, then the civil marriage. There was an interesting North Gauteng judgment on that by Colipin J, as he then was prior to him going to the Constitutional Court, where that was dealt with. And in that instance, the antenuptial contract was kicked out. To be safe, if you are entering into a customary marriage, before you even start with lobola negotiations, go to see an attorney and a notary and have the antenuptial contract drawn up, signed, registered. There is, as far as I'm aware, Johan, please confirm whether I'm correct, no time limit on how early you can sign the antenuptial contract. You can sign it today and get married in a year or 2 years. Am I correct in saying that, Johan?
Yes, that's correct.
Okay, fantastic. Right. So that would be the prudent thing when it comes to customary marriages. Carmen asks, if you are a notary and you're going to get married, would it be wise to have an independent notary instead? Yeah, I think it would be very, very, very wise. For example, and this is, I'm sure there is a legislative provision to this effect as well. We'll have a look and we'll share it if we find it. But if you look at the situation of a commissioner of oaths, I can't depose to my own affidavit. I can't be the commissioner of oaths for my own oath. I think in the same instance, the very purpose of notary public having this very high level of independence and quite a status in terms of their admission, I think it would certainly be wise to have an independent notary rather. All right, we've got some very, very kind words from folks in terms of feedback on the webinar, and thank you. You guys are so kind. I'm very, very grateful to everybody who has attended. There is a question by Stella, just to confirm: does the 3 months for registration of the ANC at the deeds office be done before the marriage, or is the drafting and signing only? Only the drafting and signing before the notary. You can register the ANC at the deeds office after the marriage, as long as it was signed before the marriage. However, as far as I know, and Johan, please correct me if I'm wrong, I believe if you get married at Home Affairs, they require the registered ANC before they'll marry you. I've heard
Yes.
this by the grapevine.
Yes, they don't. Usually, you could get away with the fact that you just give a letter that there was an antenuptial contract concluded that the notary gives with his seal. But now Home Affairs requires the physical contract, so they want to actually see. I think because of very fraud and things being committed.
Okay.
Yeah,
Fair
yeah,
enough. Yeah, I suppose you can't blame them for being careful.
yes.
Karishma asks, B versus B, any similar cases to this in South Africa? I am sure if you have a look on Jutta, you will find cases to that effect. If you can't find it, just go and have a look. If you are using an AI tool like Deep Search on GPT or Perplexity, you can go and look for it there. Just obviously be careful of hallucinations, that you don't get given dodgy case law. Go and read the cases that it spits out, Karishma. But it is quite a seminal kind of principle with ANCs, this void for vagueness. So I've no doubt that you will be able to find quite a few judgments. It is an SCA judgment. I don't think there's any constitutionality raised in that particular situation. So unless the Supreme Court of Appeal overturns itself, I think it's unlikely that B versus B will not be followed quite universally. I don't think we've got any further questions, folks. It's now 20 minutes past 7. I am extremely grateful to Johan for the preparation of the slides and the preparation of the course material for this evening. Thank you so much to Johan for that. Thank you to Nadia for setting up the webinar. And most of all, folks, thank you very much to all of you for attending. It was a lovely turnout that we had this evening, and we look forward to seeing you at our next webinars. Reminder of the Family Law Roundup this Friday at 9 o'clock. We've got some very interesting judgments. Mediators specifically, we have 2 super interesting judgments regarding mediation, which I'm going to be sharing. So please pop in for those. On that note, folks, it is now 22 minutes past 7. I'm sure all of you are yearning for your nightcap, albeit a whiskey, a tea, a water, or even a soft drink. I wish all of you a lovely evening, and I thank you all for having attended this session. We will be in touch about the second round of understanding ANCs in future, and we hope to see you there as well. So on that note, with sincere thanks from myself, Johan, Nadia, and all of us at the Think Legal team, we wish all of you a lovely evening, and I will be ending the stream in 5, 4, 3, 2, 1. Have a pleasant evening, everyone. Goodbye.